Welcome to the Friday edition of Anglican Unscripted. This is episode 142, and you're watching two guys who want to get this thing done before the weekend. I'm Kevin Carlson.
And I'm Alan Haley, and today is December 5, 2014.
Okay, I need to report that George is under the weather this week, so we're going to have Alan fill in for the Friday show. And as you guys know, we save Friday for frivolous stories. And lo and behold, we have a frivolous legal story that's appeared on the horizon, and I have Alan here to explain it. Now, first of all, for people who don't know, the Episcopal Church has used the legal system to protect dioceses. Or try to stop dioceses from leaving. They've done this in California. They've done this in Texas, South Carolina, Illinois, other places around the world.
Pittsburgh, California.
Where, the dioceses want to leave and they go to court and sue them for them not to do that. The Episcopal Church has money. It's not like they can't pay for these lawsuits. So when Alan describes what happened in this next story, you are going to be as befuddled as I am as to why they did what they did. Let's back up here and talk about South Carolina. Early on, the fight was who gets to call themselves the Diocese of South Carolina.
Correct, and who gets to use the seal and trademarks of that ancient and hallowed institution that's been around with us since 1787 or so. And so the issue was, of course, in 2012, late 2012, when the second round of disciplinary charges were brought against Bishop Lawrence, it triggered an automatic withdrawal of the diocese from the Episcopal Church. And shortly thereafter, a remnant group of people who wanted to remain Episcopal organized themselves and began using, sending out emails as though they were from the diocesan headquarters. They began using the diocesan seal and trademark in stationery and on the website they erected, and they pretended to be the Diocese of South Carolina itself, the true Episcopal diocese. Well, that didn't sit well with Bishop Lawrence and his people, and in early January they brought suit against the Episcopal Church to try to stop it. At the same time, in early January 2013, the Episcopal Church, under presiding Bishop Jeffrey Shorey, organized a convention in Charleston to form the new group, the Rump Group in South Carolina, into what the Episcopal Church then recognized as a, quote, diocese, unquote. However, it couldn't legally use that term because by then the Episcopal Church was enjoined by this South Carolina state court from letting any of its upstart groups or rump groups use the term diocese of South Carolina in the title, since that was already taken by Bishop Lawrence and his group. And shortly after this new quote-unquote diocese was formed, it was added to the lawsuit that Bishop Lawrence had brought to protect his trade name and trademarks and so on. Well, the new diocese of the Episcopal Church in South Carolina, just like every other Episcopal Church diocese, had applied to the church insurance companies, an outfit operated under a different wing of the Episcopal Church, namely the Church Pension Fund, and for a general liability insurance policy. And they probably only had paid one premium under that policy, maybe a few $1,000s or so, when they were named and joined in the lawsuit for infringing on the trademarks. And one of the paragraphs in that policy that they had purchased protected them against what's called advertising injury, where they are sued by somebody else claiming that their own marks or trademarks and so on are confusingly similar with the ones that they're using. And so, of course, they said, well, we've been sued by the Bishop Lawrence's diocese for using these trademarks, and he claims they're not just confusingly similar, they're identical to the ones we happen to be using, or borrowing, you could say.
Yeah.
In any event, that was enough to trigger the policy. Now, the insurance company resisted this claim, naturally enough, saying, wait a minute, this doesn't sound like some sort of unintentional accident that you mistakenly lifted somebody else's trademark. that happened to be similar. This sounds like intentional conduct,
Very
and
intentional.
we don't cover intentional conduct. And the church said, "Well, no, you're wrong. Under South Carolina law, we still can be sued even if our conduct wasn't intentional, and we want you to defend it." The lawsuit. So it went into federal court in South Carolina. The Episcopal Church in South Carolina sued the church pension fund insurance company to provide coverage under its policy. And that lawsuit dragged on for well into toward the end of 2013, when the judge finally issued a ruling. Yes, indeed, under South Carolina law, even unintentional conduct could be liable for trademark infringement. So therefore, the insurance company had to provide a defense.
Well, hold on. We need to back
Yeah.
up here because this is kind of confusing. Let's apply an analogy to this, which
Yeah.
may be more helpful.
Okay.
Basically, the New Rump Diocese insured a house against arson.
Right.
They went inside, poured gasoline all over the floor. Somebody threw a match over their shoulder. The building burnt down, and they filed a insurance claim for that money to recoup their losses. That's
Yeah,
pretty, you know.
Even worse, what they did was they had already burnt the house down when they bought the insurance policy. They'd already borrowed the trademarks and had been using them until the court ordered them to stop. So, but it didn't matter. They were just being sued for the infringement, so the policy in that sense covered. But yeah, that's a good analogy. And then, as I say, the trouble is that the diocese that is being supported by the Episcopal Church, on the one hand, getting all its money to operate and pay its bishop's salary and its attorneys, is now suing the Episcopal Church, on the other hand, for the money that it's having to spend on its attorneys, which it's getting from the Episcopal Church. So if you, I don't know what the analogy is for that.
There isn't one. I guess you could just say hell has frozen over. There is no analogy to it. Well, there is, because if you look, let's do a quick sec of the news. We talked about the amnesty for illegal aliens, and that Obama was going to sign a document, executive order allowing for this amnesty. We learned that he never signed the document, that he passed it over to an agency who has some quasi power to do it. It's kind of like this sleight of hand type thing going on with the Episcopal Church. It's all sleight of hand. They have the money. It's not like they're poor, but they just got $1 million out of an insurance company.
Yeah, well, which comes out of the church pensions, which goes to our retired Episcopal clergy. So, you know, somebody's ox is getting gored here, but it's certainly not the attorney's ox in South Carolina, and the insurance company ends up the loser for this conduct. But it's pretty amazing when you have, I mean, the Episcopal Church, of course, as you mentioned, is known for its scorched earth litigation policy. You try to even think of moving out of the church, you're immediately sued. And so it's probably started close to 100 lawsuits in the last 5 years, 6 years, 7 years, since the presiding bishop began her term.
Well,
and so that's what it's known for, and now it's suing itself, and that's supposedly, I think, that's the ultimate consequence of these things. They all turn in on themselves.
Sure.
And end up eating themselves up and consuming their own means. So that's all that's happened here, is the Episcopal Church has figured out a way to spend its own money massively on its own destruction.
Well, there's kind of some good news, and that's out of Texas. What's the latest news there?
Okay, in Texas, in the Fort Worth action, after that came back from the Texas Supreme Court, you remember that the Episcopal Church tried a Hail Mary pass to the U.S. Supreme Court, which it refused to take. And so now they're back in trial court in Tarrant County, and for District Judge Chupp. And he has set a date for hearing motions for summary judgment in January. And they filed their opening briefs just last week, and this motions for each one side moving for summary judgment. Now, summary judgment, if you remember, is this procedure which says we don't have to go to trial. There really aren't any disputed facts that a jury has to resolve. We all agree on what happened and what the facts are. The question is, what does the law say about those facts, Texas law, about whether there's a trust on the diocese's property and whether the trust is enforceable in favor of the Episcopal Church and its rump group. So those are the issues that are going to be argued in front of Judge Chupp, and he will come out with a decision presumably sometime in February or March of 2015.
Well, now we're coming up sometime in June they're going to have another Episcopal convention, and they're going to choose another presiding bishop. And I was thinking we need to stop using the word Hail Mary for some of these things that have been done, and we should call these things that they throw off into the middle of the world Hail Shories. Yeah, because it's sad that Mary has to have her name attached to that.
Yeah, or Hail Kate.
Hail Kate, something like that.
Right.
I don't think there's another person on the slate that could do as much suing as she's done, or do you think this is going to be a continued policy?
Well, that's going to be an interesting question, because I've long felt, and this is my personal opinion, not based on any real facts that I know, that this whole litigation drive is based on a rather unique and close relationship between the presiding bishop and her personal chancellor or attorney, David Booth Beers, because it's his law firm that is hired to carry out all this litigation on behalf of the church across the country. And so they've both done well by each other. She's given him all this legal business, and he, in the meantime, has vigorously prosecuted her point of view that people don't get to leave the church. And so that relationship, I gather, formed, rather in the process while she was after elected and before she actually assumed the office. He had, of course, been the chancellor for many years for presiding Bishop Frank Griswold and even Bishop Browning before him. So this was a case of having to get Jefferts Schori on board, but she obviously came on board quite quickly, and it was into the program because it expanded enormously under her reign, whereas Griswold had said, no, litigation, we're going to leave that to the dioceses. That's nothing of the national church's affair. But it sure changed when she took office. And so the question is going to be, I think, if Chancellor David Beers is going to remain even past this term of Catherine Jefferts Schori, or whether he's going to step down, and at that point we'll have a new chancellor on board, and we'll see whether Mr. Beers's firm continues to represent the Episcopal Church, and it's totally up in the air as far as I can see.
All right, well, you're off to start your vacation in a few minutes. You're going to San Francisco for an opera. What are you going to go see?
It's La Boheme.
Oh, okay, wow.
Yeah, beautiful music.
Yeah, that's great. Have fun, and we'll catch you sometime next week.
Okay.